Hey, good morning, good afternoon, good evening, everybody. How are we doing? It is time. It's time for a new trial. I've been keeping this one a little bit close to the vest. Defense made a motion for a mistrial. Prosecutor was up to some fuckery. Potentially damaging evidence, no basis for it. The judge specifically said, do not ask that question. Do not use that as evidence. She walked right down the path and asked the question. It may be over on Tuesday morning. Batman Bruce Wayne bitch snitch. Gerald Brooks, your constitution does not apply to me because I'm a sovereign citizen, a traveler on the land. I'm the Moorian Empire or whatever, bitch snitch. Because they're so fucking absurd. If you want to be a sovereign citizen, just do yourself a favor first. Go to YouTube here and just get every sovereign citizen that's ever been before. Find me one that won. God dang, you're right. Don't go down this. It's not the path. Don't have time for stupidity. Some clever dick on the internet didn't find the great loophole in all of the world's law. Bitch snitch. God dang, you're right. God dang, you're right. Traveler on the land. God dang, you're right. Moorish Empire. Traveler on the land. Bitch snitch. Moorish Empire. God dang, you're right. Traveler on the land. Bitch snitch. The late evening U.S. people. Hey, good morning, good afternoon, good evening, good night, whoever you are, wherever you are, whatever you're doing, whoever you're doing it with, however good it feels, etc., etc. Hey, welcome to Friday. It's Friday here. We're just wrapping up our Friday, and most of you are probably just starting your Friday. So I hope your Friday is as uneventful as mine was. Before anybody makes mention of it, we have a temporary chair here. In addition to my computer dying last Saturday, also my home office chair died on Saturday. Lincoln Kane in the house. Was up, LC? My office chair died on Saturday. My office chair died on Friday. Then my home studio chair died on Saturday, followed very shortly thereafter by my computer. So I'm waiting to get another office chair that I've ordered. So in the temporary the time period, I thought I would see if one of my wonderful Chesterfields would fit in here, and the answer is yes. I brought in the comfy chair temporarily, the comfy sofa. We've got the Chesterfield will be here. I don't know how long we'll be using the Chesterfield, but we'll see, because it looks weird to go into the whiskey. I have like my whiskey and smoking room only has one chair in it now. It looks weird, but we'll see. We'll see how it goes. But what are we doing here today? Today we are in the first stages of the run up to the Hannah Gutierrez (Reed) criminal trial. She's been charged with negligent manslaughter as well as tampering with evidence. So there you go. That's what she's been charged with, and her trial is supposed to start on the 21st. Now, I don't know if that's going to be jury selection on the 21st or if that's when opening statements are going to start. But if it's jury selection, and if they don't stream the jury selection, then we will watch her
police interrogation. We'll rewatch that. And then we'll start with the trial. Whenever it starts, we'll be covering it right here. I know other people are going to be covering it, but hey, here's the place to watch it. You know, I'm just asking you to watch it here, not somewhere else. All right, what have we got going on here right now? We've got 118 people here so far, and 56 likes. Half you haven't done your job exactly, so half you get down there and smash that like and subscribe. The like and subscribe poll today is very, very simple. Should Hannah Gutierrez be held criminally responsible for the shooting death of Halyna Hutchins? Should she be found criminally negligent? So far, 68% have said yes, and 32% have said no. All right, so there we go. Archangel says, like the wing chair, you should keep it. It fits your channel. Well, there's like 3 reasons why I can't do that. Maybe only 2, but there's I said 3, so there must be 3. 1, I need it in the other room. It belongs in the whiskey room. 2, it takes up way too much real estate. There's about this much room behind me, behind the chair until the table. So there's literally no room in here with this massive chair. And 3, it's way too comfortable. And I risk falling asleep every time I sit in these chairs because they are so comfortable. So yeah, that's not gonna be here. We're waiting for another chair. See, like my problem with the with like the chair, the office chairs that have the wheels and like the center post, I wiggle a lot, I move a lot, and so like that just eventually that looks really weird. The pole eventually just kind of leans to one side too much. It gets off center, it gets off balance, and it gets weird. And then I've had to sit on the chair at a really weird angle because of my feet hurt because of the tendonitis, and so it just kind of warped the center pole a bit, and it doesn't work. So anyway, the new chair should be here. It's being imported from China, so it could take anywhere from a week to a month, but we'll just have to see what's going on. All right, well that's enough about the chair. We've had enough time for a bunch more people to come in, so let's get into this. This is a fairly long hearing, so we're watching a pre-trial hearing. It took place a couple of days ago. I know Danny on Direct streamed it. Ian Runkle did it, and some other folks did it too. But now is my turn. So that's what we're doing today. We're going to be watching the Hannah Gutierrez pre-trial motion, and this is to, if I recall correctly, this is to she's attempting to have her charges dismissed, which spoiler alert, didn't happen. And also to get some evidence such as her prior drug use and her boyfriend's death and some alcoholic issues excluded from evidence. And that's what we're doing here today. So let's kind of watch this, shall we? Oh, but I Shoot Rope says, I have OG restored hardwood. A chair with wheels is a costly mistake. Yes, it is. And it is so hard to find like a good chair without wheels on it. And that's, I mean, like a good, I just want like one of those good old, like the OG, high back, like leather chair with 4 legs. That's all I want. I hate wheels on chairs. I always have, and I always wheel. Get it? Wheel. Anyway. All right, folks. Here we go. Let's bring this up. Share screen. Oh, and as always, the pig dog cam is locked and loaded, but because there's no room here to show the camera around the back of the chair, I've moved the dog over to the other side of the room. So if we unleash the pig dog cam, it'll be a slightly different view than normal. All right, here we go. Let me do all this. And here we go with the Hannah Gutierrez parentheses Reed trial, pre-trial hearing. Let's see. There's a little bit of dead space here before we get going, so we'll wait for it to come in.
All right. Good afternoon. The matter I'm calling is D101CR 2023-40, State of New Mexico versus Hannah Gutierrez. Parties state their name.
Here's our judge,
Carrie Morrissey and Jason Lewis, on behalf of the State of New Mexico.
I like how our cat isn't blurred out.
Good afternoon, Jason Bowles and Todd Bullion. And Ms. Gutierrez Reed is on also.
Okay. All right, so we have, I believe, 3 pending motions. Let's start with the state's motion in limine to prohibit use or testimony of OSHB findings and report.
Yes, wheels can mess up a
Thank
nice
you, Your
chair,
Honor.
which is also why I hate it, because I have
So
hardwood floors.
The state filed a motion to preclude the use of the OSHA report for the following reasons. What OSHA does is they enforce workplace safety. OSHA is never going to be in a position where they start finger pointing at certain employees. What they do is they say, employer, in this case, that being Rust Productions, you weren't doing things right. And we believe that some of the things that you weren't doing right may have led to this death. OSHA is never going to issue a report that says, we find that Hannah Gutierrez is negligent for putting a live round in a gun. That's simply not what they do. All they do is go in and investigate employers and companies and agencies to determine whether or not the employers have proper safety protocols set up. To allow information from the OSHA report to be heard by a jury, first of all, it's going to be confusing because the jury is going to look at the OSHA report and say, well, OSHA didn't find that Hannah Gutierrez did anything wrong. But the truth is that that's not what OSHA does. OSHA was not investigating Hannah Gutierrez. OSHA was investigating Rust Productions because that's what they do. That's just their job.
That's a weird argument.
Similar to, Your Honor, let's imagine that there's a domestic violence battery
Because if I recall, the OSHA report had things about live ammunition.
And the defendant,
it had things
who's
about
criminally
handling
charged
policies,
with battery, comes into court and says,
Hannah Gutierrez
hey, I had a restraining order hearing about this incident, and the judge found that I did not commit an act of abuse. So I should get to share that with the jury. Of course, we would never let that happen, because what's happening in the restraining order hearing is completely different. The standard is completely different. The evidence is completely different. Everything is completely different. We would never allow that in a criminal trial, and this is absolutely no different. One of the, as the court can see, and I understand that we're not hearing this motion today, a motion in limine was filed by the state because we're going to need the court to help us try to figure out how to rein in some of the defendant's experts. And I can tell you, Judge, I mean, in order for experts, I certainly read the defense's response, where basically what they're doing is they're saying, we're not going to give the report to the jury, but we're going to have our experts say, we read the report and we relied on the report in coming up with our expert opinion. Well, what you have to understand is, for example, one of their experts is just a movie director. All he does is direct movies. And the only thing that he's reviewed related to the evidence in this case is the OSHA report. So a man who has presumably not reviewed the statements of Ms. Gutierrez, has not reviewed the statements of any of the other participants or witnesses in the case, hasn't reviewed any of the photos, hasn't read any of the police reports, hasn't done any of that stuff, is going to come in and give an opinion because he read the OSHA report. And that's not how expert testimony works. There has to be something about what the expert is relying on that makes it appropriate for them to rely on it so that it can influence their opinion. An OSHA report isn't something that these experts can rely on. This isn't a case about whether or not there was workplace safety. If Rust Productions was on criminal trial for workplace safety, would the OSHA report be admissible? Yeah, it might be.
Yeah, her delivery isn't the greatest. I mean, we can fall. I'm trying not to stop this too much. But yeah, I mean, her delivery could use a little bit of work. She does sound a little condescending, a little gratey. But that just might be her. That just might be her style. But the person whose style I really like is the DCV Titan for being the first super chatter of the day. The first super chat to come down from the DCV Titan. Thank you so much. She should be held responsible alongside Baldwin. You see, that's the thing. People go, well, she shouldn't be held responsible. Baldwin should. And other people are saying, well, Baldwin should be held responsible, not her. This is a negligence. This is a criminal negligence case. There can be many people in this process of live ammunition finding its way on the set, into the gun, into Baldwin's hands, and into Helena Hutchins. There can be many people. There was 4 people charged. 2 have pled guilty, and 2 are fighting. So yeah, there more than one person can be criminally negligent for the death. So yeah, charge them all. But well, we don't need to go back in time. We can talk about it later. But thank you so much for being the first super chat and the second super chat. Sarah Gould, thank you so much, Sarah Gould, with the big money super chat. Just to get us a little closer, we should definitely get Straub's expert opinion on things. Hey, Strawberry, they want to hear your expert opinion on things. She can't talk. She's too busy licking Yoda's back. Thank you so much for the support, Sarah Gould. Deeply appreciated. All right, I don't much like her delivery, but you know, people have different delivery styles. Let's see what her actual arguments are. Try to see through the annoying voice
under that set of circumstances. But we can't have defense experts who are movie directors come in and say, I'm here to testify that Hannah Gutierrez didn't do anything wrong.
See, and I disagree here. Movie directors, they're the ones that know most about who is responsible for doing what, you know, what the jobs are. I could easily see him coming into some sort of expert in that regard, how things generally function on a movie set. Just to say he's a director and he has no idea what happened doesn't mean he's not qualified to talk about movie set and movie safety. I don't know, just my thought.
Because I'm a movie director and I read an OSHA report. That can't happen. That is so far afield from anything that is reliable in terms of expert opinions. So I'm asking the court to treat this the way that we would treat anything that's happening sort of in a quasi administrative hearing that's remotely related to a criminal case. It doesn't come in. It's confusing. The issues are different. Thank you.
See, it's usually the defense that are saying the jurors are going to be stupid. This is the prosecution saying the jurors are going to be stupid.
With regard to the experts, Ms. Morrissey went into another motion, which is not addressing the OSHA motion, and that's a Daubert motion. I want to talk about that later, that this is a completely late filed disguised Daubert motion, which they knew about since November when those interviews happened.
Interesting.
With regard to the OSHA specifically, Ms.
Daubert motion is a motion
at the beginning of her argument to
qualify to determine whether or not someone is qualified to be an expert.
Actually, she interviewed Mr. Genoway, who's a supervisor at OSHA, and this was back several months ago. She asked him that question, that you're not focusing on the armor. Mr. Genoway said, well, this OSHA statute does include provision that requires employees comply with OSHA standards and requirements. Yes, ultimately, they are looking at the employer. However, there is a provision that requires employees also comply with OSHA. Now, in their findings, Judge, which were comprehensive, they went through the various safety failures of various parties. Now, Mr. Genoway later says he finds that Ms. Gutierrez had issues in response to Ms. Morrissey's question, as did others. So these findings all are the context by which the jury should be allowed to review the prosecution's theories, which are solely Hannah Gutierrez Reed caused the safety failures on this set, and they want to blame her, but then they don't want the jury to have the context that another state agency, a federal OSHA, had reviewed this, and they found safety failures across the board. Now, Judge, it would distort the truth, it would keep the truth from the jury, and it would present a lack of context of the whole set, because we have a set here where many people had things that they did that led to a tragic accident. It was not Ms. Gutierrez Reed who solely caused something. And that's what the prosecution is trying to say. So they don't want us to be able to put in any defenses with regard to a state agency who found that there were multiple safety failures across the board by management. Now that's highly relevant, and it's very important to Ms. Gutierrez-Reed's case because the prosecution is going to try to blame her solely for the whole thing. So it's important that we get to counter that with the appropriate context. Experts are entitled to rely on hearsay. Now, we're not asking to introduce the report. As this court knows, police reports are not introduced because they're hearsay within hearsay, unless there's some kind of exception that comes up. We're not asking to introduce the report itself, but certain of the findings certainly can be used by an expert under the expert rules in terms of their opinions. We're not going to ask to introduce that report, however. But Judge, the premise Ms. Morrissey told you at the very start is wrong. Mr. Genoway said employees are also governed by some of the provisions of OSHA. Now, ultimately, their findings were against the employer, but they reviewed the entirety of safety conduct on that set, and the jury's entitled to hear that.
Okay, real quick here. I Shoot Rope says, wouldn't poor set safety protocol be Baldwin's responsibility? I assume you're asking that because he was listed as one of the producers. If you go and look into the contract, his producer role was explicitly financial only. It had nothing to do with the on-set operations or that. His was like, you know, talent and money only. So yeah, it would be a stretch to hold him responsible for this, but he can certainly be held responsible for his own dumb shittery.
It would really it would be a complete gutting in some ways of the defense if this court ruled out our ability to put in the context to the jury, which is what the prosecution wants. They don't want any defense, but that is a big part of our defense. In that other people caused issues and multiple witnesses, Judge, of 49 interviewed in this case, multiple witnesses talk about safety failures and rushing and production issues and things like that. We need to be able to put that into context.
Your Honor, if I may do a brief reply. So Mr. Bowles continues to say in his pleadings, and now during this hearing, that the state is singling Ms. Gutierrez out and that we are holding her solely responsible for this incident. That is a lie.
Absolutely.
Mr. Bowles knows that what he is saying is a lie. Mr. Halls was charged. Mr. Halls entered a plea. Hang on just a second. Mr. Halls was charged.
Mr. Bowles, you may do us a reply, please.
Yeah.
Let her finish.
Okay. Yeah, you're wrong, buddy.
Mr. Halls was charged. Mr. Halls entered a plea. Mr. Baldwin has been indicted. The people who the state believes have criminal culpability for the death of Helena Hutchins have all been charged.
I said they charged three
people.
people.
So let's make that clear. Every time Mr. Bowles says that during a hearing or in a pleading, it is not true, and he knows that it is not true. Having said that, yes, of course, OSHA is going to look at the conduct of employees in order to determine whether or not the employer had adequate safety protocols in place. And that's exactly what they did in this case. And look, this is the case of Hannah Gutierrez. And there are certain people that Mr. Bowles, under the law, can point to and say, this person shares responsibility with her. Alec Baldwin is a perfect example. Mr. Bowles' defense is going to be Alec Baldwin pulled the trigger and he shouldn't have pulled the trigger, and that causes issues with proximate cause. Those are all legitimate legal defenses. An OSHA report that basically finds Rust Productions had some liability, but doesn't comment on the fact that there is evidence that Hannah Gutierrez brought the live rounds on set. There is evidence that Hannah Gutierrez did not find and remove those live rounds for 12 days until Helena Hutchins was shot. None of that is in this OSHA report. So if we have experts take the witness stand and say, I'm a Hollywood director and I read an OSHA report And I'm here to tell you that Ms. Gutierrez didn't do anything wrong. We are so far afield of what expert testimony is supposed to be. Expert testimony is supposed to be reliable. What the expert relies on has to be relevant. If the court eliminates the OSHA findings from the trial, what the court will be doing is just simply leaving the jury with the relevant information and the relevant evidence. This is not relevant evidence. This is a smoke screen that Mr. Bowles wants to use to convince a jury that Hannah Gutierrez has absolutely no culpability when OSHA was simply not tasked with answering that question. Thank you.
All right, let's hear your sir rebuttal.
Judge,
Mr.
thank you.
Bowles.
Thank you, Your Honor. Judge, actually, that is not correct. The relevant information is the context of the OSHA report. Now, if Ms. Morrissey's case was just individual, discrete instances, for example, loading the firearm, for example, how did the live rounds get on set, which we have plenty of evidence it was somebody else that put those live rounds on set. But if they were just discrete instances, then her argument would make more sense. But what they want to put on a trial, and the court will see, is a series of, they're going to show this whole set was negligent in their opinion. And they've written this in pleadings. There's negligence all over the set. Well, the problem is then the jury doesn't hear the context of the findings.
In the chat.
By
it's
the
not Mr.
production
Bowles,
and everybody else that
Bowles,
caused these safety failures.
B-O-W-L-E-S.
So we have interviewed Lorenzo Montoya, the investigator, and Bob Genoway, the supervisor. Those people are we're not talking about, they're not experts. They're the actual people who did the investigation. Now, we're not going to ask a Hollywood director to say because of OSHA, there was nothing wrong. Ms. Gutierrez-Reed did nothing. We're not going to do that, but that's a separate motion. That's an expert. She can attack the expert later. And the last thing, Judge, I'm going to say, the personal attacks, I do take objection to, and I'm going to put that on the record because it's been in the pleadings and it continues by Ms. Morrissey.
But you kind of did lie, though, dude. You kind of did lie.
Thank you. The court makes the
You said that the prosecution was seeking to hold her, Hannah Gutierrez, solely responsible. And she said that's a lie. We've charged Baldwin and David Halls pled guilty. So and again, at the beginning, for some reason, I said there was 4 people charged and 2 pled. Only 3 people were charged and David Halls pled. I have to correct that. Sorry, guys. Lorax was wrong.
following ruling with respect to the state's motion in limine to prohibit use of testimony of OSHB findings and report. The court denies the state's motion in limine. First, the court finds and concludes that pursuant to 11-401 NMRA,
good.
The OSHB findings and report constitute relevant evidence because it has a tendency to make a fact more or less probable than it would be without the evidence. And the fact is of consequence in determining the action. For instance, the findings and report may impact the state's theory of causation. Second, pursuant to Rule 11-403, the court finds and concludes that the probative value of the OSHB...
Probative? Okay, I know you're from New Mexico, Judge, but probative value? She just said, if she says it again, I'm going to freak out. I'll just give her a 1 off for a mispronunciation. Sonia or Chris, what's up? Thank you so much for the super chat. She makes valid points, but the condescension is infuriating. She sounds like nails on a chalkboard. Yeah, the prosecutor she doesn't have the greatest delivery. She is a bit condescending. She's a bit screechy. And it might be hard for a jury to look past that, but we kind of need to. But we can't have a judge saying probative. I think it was the missing mom trial that Danny On is doing. The lawyer was driving me crazy because they were talking about affidavits, and the affiant is the person that signed the affidavit. They kept calling the affiant. The affidavit signed by the affiant, and that was driving me nuts. Probative driving. Now, don't get me wrong. Voir dire is the correct pronunciation for that. So anybody that thinks you're annoyed by the pronunciation voir dire, you're just wrong because that's how God pronounces it.
Findings and report is not substantially outweighed by a danger of unfair prejudice. confusing the issues, or misleading the jury. Rather, the state can address any perceived limitations of the report via cross-examination of the witness by whom the report is addressed. Defense, prepare that motion.
Yes, Your
All
Honor.
right. We're going to move on to the motion to sever charges and exclude mention of alleged other bad acts.
Okay, now this is going to be interesting.
Go ahead.
Good afternoon, Judge. I'll be arguing that on behalf of Ms. Gutierrez-Reed. We are the movement.
That is a groomed beard. That is a groomed fat covering beard right there. No, see, this is going to be the interesting part, because he's going to be asking to have things like her prior drug use excluded. And I believe her boyfriend's death in a motorcycle accident, her past alcohol problems. So we'll have to. This is actually the part of the argument I was looking forward to. And while we're here, Nick Starro with 20 more sexy monies. I hope Attorney Balls second chairs is Miss Deep. Again, it's Bowles, Bowles. I know you're fixated on balls, Nick. Just kidding, brother. It is Bowles though.
That's my understanding. The state,
but this guy has the cool name. This guy's name is Mr. Bullion. Well, you can either say it's unfortunate, like bullion cubes, or like gold bullion. This guy's name is Mr. Bullion. So there you go.
Notwithstanding us being.
And real quick, Kaiser Pineapple says, "What corn cob you smoking today? Looks like a Vermont freehand forever." This is a custom made pipe. Let me see if we can get this here. This is a straight up custom cob pipe made by a guy named Saywolf. Saywolf Pipes is the guy's name. This is I should talk about this pipe sometime. Because the guy that made it was anyway, we'll talk about it later. We'll talk about it on a break. But yeah, it's a total custom build pipe.
In the movement actually carries the burden here to show a fact and consequence. I can go first, or the state can go first. Typically, the state would go first because they bear the burden.
Ms. Morrissey.
This is not my motion. I don't see why I should have to go.
Do you wish to go first?
No.
All right, thank you.
Okay. Judge, we filed our initial motion to sever this tampering charge, and we challenged the state to come forth with some theory of admissibility. In their response, they spell out how they believe these acts are connected, and those arguments are based solely and completely on speculation. For instance, in the state's motion, in the state's response, they indicate that Hannah was nervous in the presence of police officers, and they attribute that to potential cocaine use. That's not supported by anything. And they identify a plausible alternative explanation as they're discussing it, saying that she could be under the excitement or stress of the event. There's case law that we cited in our reply that says that when there are multiple plausible explanations for something, that's not probative evidence. That's speculation that runs afoul of the jury instruction to only decide a case based on its facts instead of making speculation and guess. In essence, what the state is seeking to do is they want the jury to assume that at some point in time, prior to going to work on October 21st, 2021, that Ms. Gutierrez-Reed ingested cocaine. They have no evidence as to whether that actually happened. They have no evidence as to when that would have happened. They have no evidence as to how much cocaine would have been consumed, or how it would affect Ms. Gutierrez-Reed's body or her mental perception and acuity.
Probably like someone on coke.
Those are all very critical assumptions that the government wants to take as a first step. Following that, they want to speculate further that this assumed drug use would be affecting Ms. Gutierrez-Reed while she's at work. They have no expert testimony to support this, but really more importantly, they have no facts. There's a case that we cited, State versus Downey, which discussed the use of retrograde extrapolation. The argument that the state seeks to make here is very similar to Downey, but there's some differences. In Downey, they actually had a data point to work backwards from. The gentleman in that case had actually been arrested and his blood was tested. And the expert attempted to work backwards.
Well, see, that's interesting. I find it interesting that they didn't
identifying that
drug
there was
test
no
on
information
everyone
as to
that
when
was
this
on the set.
gentleman had first consumed alcohol. No information as to how it was being metabolized in his body. They threw that opinion out, saying that it was mere guesswork. That is exactly what the state is seeking to do here. Furthermore, Judge, the basic premise that they want the jury to assume that Ms. Gutierrez-Reed was using drugs is based on a propensity argument. This is expressly prohibited in 404. That's the whole point of the rule, is to not argue that someone has a character trait, therefore they must have acted in conformity with a character trait. Their response makes this very clear that that's what they're doing. They describe Ms. Gutierrez-Reed as, and I quote, a person who uses drugs, person who abuses substances. They are attempting with their evidence to show that she has this character trait, and then they want to argue that she acted in conformity with it. That's a propensity evidence, a propensity argument, clear and simple. The rules ban that. They cannot do that.
Okay, while he's pausing here, KT says Runkle and Robb said no reasonable suspicion allowed them to test. I would agree with that. I would agree with that. I was thinking more from the employment side to cover the employer's ass. Because employees are subject to random drug testing in almost every workforce. Just as a part of your employment. Like for example, on ships, if there's an accident on a ship, like a serious accident, everybody gets alcohol and drug tested just to cover the owner's ass, to say that none of our employees were drunk or high when this accident happened. So I was speaking more from the employer side. Should have made that clear. Sorry. Yeah. I mean, criminally, the cops, yeah, I don't think they had, they would have a lot of probable cause to do
that. In the state's response through pages 4 to 6, they include several text messages, and they argue that those provide their factual foundation here. None of those messages, none of them, not a single one, indicates or suggests that Ms. Gutierrez-Reed had used cocaine on any point in time on the day of incident or the day before the day of incident. At best for the government, there is a text that suggests that Ms. Gutierrez-Reed may have used marijuana.
You mean
they make reference to, I just smoked, and then the state puts in parentheses referring to marijuana. There
were other witnesses that said they were smoking marijuana. Other people said that. I mean, I don't think she mentioned marijuana. We'll have to double check her interrogation again, but I know she mentioned drink. I forgot to read the super chats here. Sonia or Chris, this is not my motion. Wow. Both sides are kind of not stellar and on point. And again, this guy is really not very passionate. I mean, there's no jury there. There's no reason to really be fired up and passionate, but just don't be monotone. That's really all you want to add. I mean, don't be monotone. You don't have to be all fiery and you deliver a great deal of rhetoric to impress a jury. You're just talking to the judge about whether to let certain evidence in or not. So you don't need to be dynamic. Just show a little life. Just, that's all. Somewhere between this guy and the prosecutor. That's where like down here is this guy, and then the other side of the meter would be the prosecutor. So you kind of get your levels right about in the middle. And Island says, why doesn't the state want the OSHA report? Why does the state want the OSHA report out? Explain like I'm a dumb. Well, you're not a dumb. Basically, their argument was saying the OSHA report deals with safety violations and safety factors that the company, the production company, should follow or didn't follow. It doesn't mention Hannah Gutierrez by name as doing anything wrong, because the OSHA reports don't point fingers at individual people. So the prosecution is saying the jury is going to be confused if we bring this in, because they're going to hear the report and they're going to say, oh, well, nowhere in here does it say that Hannah Gutierrez Reed was negligent or did anything wrong. So therefore, she must not have done anything wrong. So that's why they want it out. They want it because the jury will be confused and think that because she's not mentioned in there, it means that she wasn't negligent. Well, they lost, so it's coming in. And Notes on a Phone says, on a sidebar, will you be covering Fanny's how not to give evidence testimony? She managed to outdo Amber Heard, in my opinion. Oh, Lamau. Sorry, that was, yeah. Lamau. No, there's lots of other people covering it. I hate political crap, even lawsuits relating to political crap. I can't stand it. So there's other people doing a far better job and far more entertaining job than I am. So yeah, sorry about that. Antonio Chris again with the heavy super chat before we jump back into this. We are now halfway to Pig Dog Cam. I'm a paramedic who for the last 8 years has worked on the industrial safety side. After any property damage or any injury, a drug test is mandatory for most employers. But it looks like this site was a goat rodeo. Yep, that's haven't heard the term goat roper in quite a while. It seems to be that way. So I mean, that's what I was saying. I was surprised that the company didn't immediately order drug tests for all the employees so that they can CYA at a later point in time and say, nope, wasn't us. Nobody, we didn't have none of them druggies. Now, of course, it's a movie deal, so probably everybody was drunk and doing drugs. All right, let's jump back into this. Thank you so much, Sonny or Chris, for the super chat.
The government, in its argument, marijuana use is not relevant here in connecting this tampering with evidence, which the government claims is cocaine, and the involuntary manslaughter. There's no connection at all with marijuana use.
Well, that's for the state to prove.
Further, Judge,
that's a bad argument.
The state, in its argument, includes several photos of ammunition and claims that they are easily visually distinguished between live and dummy rounds.
True.
The state's expert, Mr. Carpenter, 2 years ago on News Nation, stated that it is very difficult to distinguish live ammunition from dummy rounds.
It is not.
And that is, in fact, the point of dummy ammunition.
No, it's not.
Real.
You can literally,
so that way
you can literally take someone who has never seen a real bullet in their life
in a gun belt that it
and
looks
within
real.
1 minute, you can teach them to identify dummies, blanks, and real rounds blindfolded.
That Ms.
It's
Gutierrez
very
Reed was
easy to tell.
Impaired to the point that she couldn't visually distinguish live rounds from dummy rounds. It just doesn't work. Dummy rounds are supposed to look like live rounds.
Yeah, look at the back of them. Look where the primer sits. Shake them a little bit.
Judge, this argument would be extremely prejudicial.
All right, this dude is starting to annoy me. That's a shitty argument. That is just as Ian Runkle would say, horseshit. That's just a horseshit argument. As I said, literally someone who has never seen a live round in their life can be taught to differentiate between live rounds, dummy rounds, and blanks instantly. Well, I mean, a blank, literally, they don't look anything like dummy rounds or live rounds. So get them out of there. Just, I mean, you can tell a blank that quick. A dummy round, it has the lead end on it, so it looks. The dummy rounds are used so that when the camera is focused down the barrel of the gun, you can see the bullets around, you know, in the cylinder. You can see them go, oh, look, there's actually bullets in there. But they'll either have the primers knocked out, or they'll have a primer with that already has the firing pin mark in it to show that they're not live rounds, or they'll be empty except for 2 or 3 small BBs in there. So there's no way you couldn't instantly know by touching and even the most cursory of looks. There's no way you couldn't differentiate between a live round and a dummy round unless you were a complete fucking moron. And there seemed to have been a lot of them on this set.
To misread, if the jury were to believe that she is someone who,
yes, exactly. But there's so many different ways.
The government wants them to believe goes to work while she's intoxicated, that has extreme prejudice, and there's no probative value because they have no foundation.
Oh, yeah, and it is her job to know.
Furthermore, Judge, the state did not address in their response the argument specifically about the rule on joinder, 5203. 5203A1 states that you have to have acts that are similar in nature to join. The 2 crimes here that Ms. Gutierrez-Reed is charged with, tampering and involuntary manslaughter, they're very different from one another. They're not similar.
So what he wants to do is separate the 2 charges into 2 different trials.
5203A2,
the trial for manslaughter and the
trial
trial for
have acts that are linked
evidence tampering
together as a series of acts. Here we don't have that either because there's no evidence actually linking the alleged tampering with the alleged involuntary manslaughter. So we would ask, Judge, for those reasons, for the defendant's motion to be granted and for that count to be severed, and also that the state be prohibited during the involuntary manslaughter trial from bringing any of that up. Anything about substance abuse, anything about drug use.
Drug use and substance abuse could be very, very important in this.
Thank you.
I was with him until he made that stupid argument.
I'm a little confused just in terms of the procedure and the motions that we're hearing today. The court gave the state a deadline of February 2nd to file a 404B notice. We did that. We filed it on February 2nd. The defense has never filed a motion to exclude the specific things that are in that 404B notice. So I'm not sure exactly where we are on actually addressing the 404B issues that the state wants to get into. What the defense is not allowed to do is to look at our 404B notice and then just kind of incorporate into their reply their motion to exclude, because by doing so, it doesn't provide us with the opportunity to file a response. So I would ask the court to give us some clarification in terms of how we need to address all of these 404B issues. Having said that, I can move into the motion to sever. So
let me address your concern.
Sure.
So in your response, you identified not just the conversation about the cocaine after the death. You went through all these text messages that you intended to introduce. And you said that these all showed that she was working impaired.
Mm-hmm.
So it does go to the severance motion.
Again, interesting.
It's basically in the severance motion, but you also noticed it in the prior prior bad acts. But we have to address it in the severance motion because you're maintaining that her being under the influence offset, because all these texts are offset is a series of acts connected to the manslaughter. And so you also state in your response
What?
a couple of things. Number one, and I think this goes to Mr. Bullion's response, that the jury's going to be able to conclude all this. This is not, you have no expert witness, to my knowledge, that's going to say, if you do alcohol, marijuana, and cocaine, and I don't know when this expert's going to be able to know, other than the marijuana the night before, and not knowing any of the amounts, that she worked impaired on October 21st. So you also say that you have many people, you have extensive texts, which I think we have the extent of them. And then you also say you have many eyewitnesses to her using drugs on the set of filming Rust. And the big question for the court, and what I would like you to address, is the nexus between your allegations of her drug use and her impairment on October 21. Because at this point, I agree with Mr. Bullion. It's completely speculative. So until you can, I'm hopeful that your statement is what is the nexus for you, because you're going to have to identify what the nexus is.
Well, let's give her a chance and let her hear what she has to say.
One of the primary issues in this case is that the negligent act is not limited to October 21st. There were a series of negligent acts that we have very concrete evidence of, that Ms. Gutierrez was engaging in these negligent acts as she moves through the filming of the movie during all of those days.
Yeah, but
so
what did smoking weed 4 days before this have to do with
between her and Mr. Trujillo about using cocaine? She's showing up to work the next day and she is failing to remove those live rounds that are already on set that we can see in photos. And if you want me to show the photos where we can actually see them on the set, one of them we can see in her hand. One of them on the 13th
That's a
of
bad picture to
October
have.
is in her hand, for heaven's sake.
Let me just
But again,
interrupt
what does
you,
this have to do with the
because
shooting
it's not
day?
to me that it's in her hand. How are you connecting her use of these of
Drugs.
marijuana? Coke was one time in these text messages. Do you have anything more than these text messages, I guess is what I'm asking,
So
other than,
I apologize.
and that the intoxication of being blackout drunk, and that her admission to police officers that she drank alcohol and smoked marijuana
Oh, she did mention
on
it in her.
evenings, which I don't know if it's a paraphrase, and I'd have to see that.
Yeah,
But
yeah.
I'm not persuaded that this use as evidence in the text messages is enough to for you to connect her to the impairment. And
Well, exactly. I mean, let's say the shooting was what, October 21st or October 22nd. Let's say she was doing coke on the 18th. What does her use of coke on the 18th have to do with the shooting on the 22nd or the 21st, whenever it was? Let's say she was smoking marijuana the 2 days before. What does that have to do with the day of the shooting? The judge is rightly asking her, you need to connect this up. You need to show what relevance the behavior whenever she did it had to do with the shooting and the tampering.
the fact that you're saying that she was putting live rounds in begs the question.
So we have a witness who is going to say that Ms. Gutierrez kept ammunition in her hotel room and at the same time would become impaired by marijuana. So obviously the nexus
what does
there
it have to do
is
with going?
We have a person who is in possession of ammunition to be used on this movie set, and she's high on marijuana.
In her hotel
So
room.
that,
What does that have to do?
Your
with
Honor,
what
I think
happened
absolutely
on
has to
set?
come in. There's no question about that.
There
She's
is.
in possession of the ammunition, and she's high on marijuana, and she brings the ammunition to the set. So we have that.
You're gonna have to prove she was
And
high.
look,
Let me interrupt.
when she
Let
brought
me
it.
interrupt you. Because these have to be specific. I'm going to make a ruling today. Being high on marijuana, that was on October 20th.
Mhm.
Is that
no,
right?
Your Honor, that's not the one I'm talking about.
What are you talking
Which one
about?
is it?
But we have a
Well,
witness. Sorry.
Okay, so you have a witness that says off hours, she had ammo in her room. Number one, I don't know what that means.
Oh, she
Was
can.
it on a
She
shelf?
can bunning
Was
sensations.
it, was she playing with it? I don't know what that means. So I don't know how probative that is rather than prejudicial. So if that's the series of acts that she was smoking high on marijuana, you have a witness to say high, and that she was
High.
she had ammo in her room, and you want to make the nexus.
The witness
that
is
that
Nick Sparrow.
shows
He's just gonna come in and say hi.
that this cocaine in her pocket or hotel that all these are a series of acts that show involuntary manslaughter. I'm having a hard time, to be honest.
No, and I apologize, Your Honor. I think you're misunderstanding me. It's relevant that she's high on marijuana and has the ammunition in her room because we can demonstrate that she was impaired while in possession of ammunition that was brought onto this movie set. That's it. Full stop in terms of that testimony. That doesn't have anything to do with cocaine use. We have a witness, and look, tampering is always joined with its companion offense. For example, we frequently see a tampering charge because somebody disposes of a gun. Does the state have to prove that it was a real gun and that it was the exact gun that was used in the killing? Of course not. The defendant disposed of the gun and we have evidence to it, so it comes in. Ms. Gutierrez was under investigation on
That was a
October
weird
21st
thing to say. That was an
because somebody on
incredibly
the movie
weird thing
set
to say.
died, and when she got back to her hotel room, she took what our witness is going to say she was able to identify as cocaine and handed it to her.
Dude, if I fucked up in a way that resulted in the death of someone else, I would probably run back to my hotel room and do massive amounts of drugs myself, for whatever reason. But I don't like her arguments. I can sort of see what she's trying to say, but I don't like it. She's making weird analogies.
And then she spent 4 weeks trying to get it back over text message. That's just tampering. Tampering doesn't get severed from its companion offense because it goes directly to consciousness of guilt. Why are you handing off a bag of your cocaine?
Because the fucking cops are going to search everything you own and you don't want your coke to be found by the cops. That's why. Just because you hand off a bag of coke doesn't mean you're doing it because you were high on coke when this happened and you don't want to be found out.
To someone who you hardly know after you've gotten back from the police station. It's consciousness of guilt. So in terms of the severance,
I don't agree with that.
The severance doesn't work at all. We would never sever tampering from the companion offense for the exact reason that I just articulated. If the court concludes that all of these text messages about her cocaine and marijuana,
with the
marijuana use in the evening
reasons, but she's arguing it
we
terribly.
certainly can accept that. But the fact that she handed off what another person is going to say she was able to identify as cocaine is absolutely relevant. It is tampering with evidence, and it was handed off not because she's trying to be friendly. She's trying to get rid of it so that the cops don't find it.
Yes.
And all of that circumstantial evidence is right there. So if the court doesn't want the text messages about the cocaine to come in, I think that's perfectly reasonable.
I agree with
But
you,
at the
Ona.
same time,
That's all it
if Ms.
is.
Gutierrez takes the witness stand and says, I didn't use cocaine or I don't use cocaine.
Well, you know what? She doesn't have to. You can't rely on that argument because she doesn't have to take the stand and prove this. She doesn't have to prove it didn't happen. You have to prove the nexus between this consciousness of guilt about the murder, as opposed to what Ona was saying, and just consciousness of guilt of having a bag of coke on you. But see, I agree that they should not be severed. If you're charged with a crime and you're charged with tampering with evidence relating to that crime, they shouldn't be separated into two separate trials. But she is doing a shit job of arguing it.
Then I think we're dealing with a different story.
Judge, if I
Okay,
could
but what I
briefly-
want to ask about is I understand about the tampering with evidence, but they're asking for a severance. And they're asking for a severance because what needs to be joined is based on the same conduct or on a series of acts either connected together. Okay, so we're looking for a series of acts connected together. That can be consciousness of guilt, but do you have a series of acts connected together other than
cocaine,
the tampering of evidence, other than the getting rid of the cocaine?
She brought live rounds onto a movie set.
So, well, I mean, not
She
so.
failed to discover them for 12 days. She loaded one of them into a gun. It was then manipulated by an actor, and very foreseeably, someone died. She was taken to the police station to give a statement. After she got back from giving her statement, she took what appeared, and our witness would testify, was a bag of cocaine, handed it to her,
Cocaine.
and said, hang on to this for me, because she was under police investigation. It's the exact same connection you would see with any tampering charge.
No. See, you got to make this link somehow between the coke and the negligence. She's not doing it. All I'm hearing is a girl who knows she's in a truckload of shit. I mean, the cops are going to be after her hotter than a horny toad on a sun-baked rock. I mean, she knows, like, okay, I've already fucked up and they're coming. Now I don't need a drug charge added on top of this. Here, take this and get rid of it. That's all I'm seeing here. Not, oh my God, I was high on coke, and then they'll find this and they'll know I was high on coke. So this is a consciousness of my guilt. If they find this, they'll know I'm guilty of negligence. Get rid of this. It's not, she's not making this connection at all, in my mind.
All right,
I'm
thank
under
you.
police investigation. I'm handing my gun off.
All right, reply.
No.
Judge, this is very different than someone trying to conceal a murder weapon.
Exactly.
If someone murders someone intentionally and they conceal the murder weapon, there's an obvious relevance to the weapon. So the weapon is obviously evidence in the murder. Here, the state has not provided any argument that this supposed cocaine, which they're saying was tampered with, is relevant to the involuntary manslaughter.
Exactly, my friend.
They have tried to do that by making this impairment argument, which they cannot make. They don't have the necessary facts. They don't have the necessary foundation. They don't have the necessary experts. It's all based on speculation and a propensity argument. Absent some competent and admissible evidence that Ms. Gutierrez-Reed was in
Island, get
fact,
better soon.
impaired by cocaine on the date of incident, there is no relevance whatsoever to her possessing cocaine or any other drug. It's markedly different than someone concealing a murder weapon.
Yeah, right.
They haven't established the relevance of this supposed cocaine. They've tried and they've failed. It
Your Honor,
has
I'm
nothing.
Wait, no,
Let
don't
him
interrupt
finish.
him, please. Okay. All right. The court makes
I'll let the
following
judge
ruling.
do her job.
Or you're not finished, Mr. Bouillon?
No,
sorry.
Judge, I'm
Being very
good.
repetitive. Okay.
I'm okay. Thank you,
All
Judge.
right. All right. So I think I'm satisfied with what Ms. Morrissey was saying. The concern for me, Ms. Morrissey, was what Mr. Bullion is describing as propensity, is these time periods of that you had quoted in there. So I'm going to make the following ruling, and then I'm going to identify a couple of things. So Rule 5203A, it does talk about, and this is what I was looking at, are based on the same conduct or on a series of acts connected together. So basically, what Ms. Morrissey's talking about with tampering of evidence is the same conduct or series of acts that she's talking about with the involuntary manslaughter charge. And so these series of acts are related to these charges. The state has a sufficient proffer that the following with respect to what she's planning on bringing in surpasses the argument for severance. So I do think that the text messages that you showed from 9/22, 10/16, 10/17, 10/18, 10/20, and 10/21, the relevant ones are the one where she's smoking weed with the ammo in the hotel room.
Okay, yes.
And that
Give me
she's
that one.
smoking in the jacuzzi.
I'll give you that
I think
one.
those are the relevant ones of
Yeah.
the other of the
Okay.
acts that you in your response said you were going to show, plus the text messages with respect to after the fact with, I can't remember that lady's name, where she handed off the cocaine. But other than that, I do agree that the remainder of your intended text messages, as well as that intoxication the weekend before, are not that they're propensity evidence versus probative evidence, and they would be unfair
All right. Okay.
to the defendant.
She does not know how to
Understood.
pronounce probative. All right. Well, this is a good place to pause here for just a bit of a second. So that was a partial victory for the defense. Like things that like the drunkenness the weekend before and all the other text messages. I think because she is admitted essentially to smoking marijuana in jacuzzi and the night before, those emails should come in. I believe those emails should come in. The cocaine thing, I don't like that. I think based on what the prosecutor just provided was not enough to link the cocaine to the manslaughter. I think what she's doing here is telling the prosecutor, you're very, very close to the line on this one. I'm going to give you the benefit of the doubt. I'm going to allow this in. But when it comes to trial, you better have some evidence to back this up. So I think she's just giving the prosecution the benefit of the doubt on this. We'll just have to see. But I don't like the cocaine stuff coming in. But that's the judge's ruling, and we're halfway through ish. So thank you everybody for being here. We've got 243 people here right now. I know there's a lot going on with the Fanny stuff, and we've got the horrible Montgomery case going on. We've got the missing mom trial going on. We got a lot going on, and 243 of you have decided to be here with me, and I deeply appreciate that. I'm very grateful to every one of you that's here. 165 likes. It's like 80 of you, at least 80 of you haven't done your job. So get down there and smash that like button during this next 30 seconds of our break. We're going to be doing this for about 30 more seconds. So everybody, make sure you hit the like button and subscribe. If you haven't subscribed to me, I would be incredibly honored if you would do that. And if you have already subscribed, make sure that you are still subscribed. Excuse me while I cough here. I'm back. So just make sure you're still subscribed, hit the like button, and take our like and subscribe poll. Halfway through, where are we on this thing here? Like, subscribe, and vote. Should Hannah be held criminally responsible for the shooting death of Helena Hutchins. 71%. Okay, we've gone up a little bit. It was 68% earlier. 71% of you say yes, and only 29% of you say no. All right, we'll check back in at the end and see how that changed. We are currently halfway to the pig dog cam, so bear that in mind if we want to see the hounds. And by the way, let's see. So again, the trial is supposed to start on the 21st. We'll pick it up when the opening arguments begin, or if they stream the jury selection, which I highly doubt. They don't do that much anymore. We'll do that, but otherwise we'll look at her interrogation, because her interrogation by the police was literally among the first Legal Vices videos that I did, was reviewing her questioning by the police. So we'll go back and we'll revisit that. We'll look at it again right before the trial starts. Monday, we should be doing a Maritime Monday. We'll play Tuesday by ear. Wednesday will either be the opening statements or her interrogation by the police. Then we'll follow this on through. And next Friday, however, is F It Friday, where we just say F it. We have a great panel of guests. A lot of people here in chat, Ozzy and Nick. You guys will be getting your invites and things like that. So we'll be doing that next Friday. So stay tuned for that great panel of guests where I just grift. I grift for shots. That's all we do. You throw your money at me and I take shots. It's always great. It's always good. So stay tuned next Friday for that. All right. Oh my gosh, we do have a super chat in here. Now see, now I've got to find the deal here. Where's the deal? Got to find the deal. We need the deal. I need to do this here more, because I got a new sound thingy. I got a Rodecaster Duo, so I've had to reload all of my sounds. I'm trying to find. Oh, there's the Release the Hounds. I got to remember hounds are on page 2 of the soundboard. So all right, there we go. Bring in the reason we're talking about that is because Sonia Chris has just done a very, very generous thing for which he gets a big foghorn. Cry havoc, and
Release the hounds.
We've reached Release the Hounds level. Thank you so much for that, Chris. That is very, very generous of you. We're gonna hit play here again. While we're doing that, I'll set up my co-host cam, and we'll unleash the doggos. Looks like we've got Yoda on tap. Strawberry is under my desk. And I don't think it'd be fair to kick her and make her move. All right, so let's do that. Let's get back into this. Thank you, everybody. And thank you for those of you that hit the like button while we were doing this. Let's get right back into this.
So the motion to sever is denied. Please prepare that order, Ms. Morrissey.
Yes, Your Honor.
All right, let's go to the motion to sever charges and exclude mention of alleged. Oh, sorry. Let's go to the motion for dismissal, or in the alternative, to suppress all disclosures and use of attorney-client communications, and the recusal of the prosecutors.
Oh, they want to
Thank you,
recuse
Your Honor.
the prosecutors.
Your Honor, 2 hearings ago, Ms. Morrissey conceded to this court that this was not correct, it was not right, and that the search should be suppressed and everything flowing from that. She conceded that. She also stated in an email attached to our motion in Exhibit D, to our motion to dismiss, I believe very strongly in the attorney-client privilege and will consider anything you propose to suppress the communications. That is our Exhibit D, and that was July 25th, 2023. It was only after we filed our motion for the first time that Ms. Morrissey chose to personally attack myself and Ms. Gutierrez-Reed and to raise a belated argument of waiver. And I want to get to that in a little bit, but I want to just stress how utterly egregious what has happened is. This court requested, and this court took steps to review in camera a series of attorney-client privilege communications, which are cited in our motion at footnote 3. In an 18,000-page document, there are numerous pages of attorney-client communications between myself and Ms. Gutierrez-Reed. Initially, in December 8th of 2022, I'm sorry, 2021, the years, I'm going to make sure I get the dates right. Ms. Gutierrez-Reed's phone was extracted by Sheriff Hancock, Detective Hancock. Prior to that extraction, we had communications by phone and by text. was very clear, and Detective Hancock.
May I interrupt you for a minute?
Yeah.
Detective Hancock was here, but because she's not a party, she was not allowed. Is she going to be called as a witness by somebody?
Judge, I had subpoenaed her in case the court had questions, but I was going to make my argument, and then if the court, she would be available.
All right. Thank you. All right. Just so you know. Thank you.
Okay, this is an interesting question here. Island says, wait, do they want her recused for being mean? How did she get the privileged comms? Well, I mean, really the only way they would get the privileged communications is if they were mistakenly given to her during the discovery process. That is not that uncommon. And you go, oh, we shouldn't have given you that. That's privileged. So it seems to me that's what they're doing. I'm not sure how they got them or what the circumstances were around it. But you know, so they're saying, okay, we gave you some documents that we shouldn't have given you, so you can't use them. That seems to be, it was waived. Interesting. I'm not sure about that. I do not know how they got them or why, but now apparently that, you know, I was just assuming that they accidentally gave them some documents. When, okay, you got some stuff that you shouldn't have.
Yes, thank you, Your Honor. And so in preparing a record of this court did get in-camera submission by the attorney for Seth Kenney from these communications. And there was 18,000 pages and
You're right.
numerous pages of attorney-client communications that were extracted.
You're right. They were extracted.
The initial extraction
you're absolutely
by
right.
Detective Hancock that occurred on December 8th went to the RCFL. The RCFL then was given a filter,
Chris.
Which we now know from Byron French, with certain names. My name was not one of those. So Detective Hancock in her first report knew, and as Ms. Morrissey admitted in an email, presumably she excluded the attorney-client. Well, she did. She did. So she knew in her professionalism and our communications and our discussions that those were not, I mean, they're not fair game. They're not something we would agree to or ever waived or ever said you can look at our communications. So Detective Hancock excluded those. The report came back was 1,000 pages.
Just because she volunteered the phone doesn't mean that they automatically
July
agree
11th
to
of
allow anything on the phone to be used.
Ms. Morrissey, we have a hearing. She gets another report from RCFL, which goes to her expert in California. That expert in California then runs an 18,000 page report from 1,000 pages to 18,000.
God.
The very next day, on July 12, 2023, Ms. Morrissey, after she's talked to Seth Kenney, gives him the whole 18,000 pages without doing a attorney-client filter, without doing an IPRA review, which we've cited the IPRA statute, which requires that attorney-client communications are not, they're excludable. They're not something you turn over in an IPRA request. Well, Ms. Morrissey didn't have an intake team. She didn't have an IPRA unit. She just unilaterally, as a special prosecutor, released all 18,000 pages to Seth Kenney. This was July 12, 2023. On July 25th, 2023, she then emails myself and Mr. Bullion and indicated, it has come to my attention that the second cell extraction contained text messages between you and your client. She then relates that she immediately told Mr. Kenney to delete his copy. This is 12 days later. He's had him for 12 days or 13 days. And then she has reached out to Mr. Kenney, requested he delete him, and then said, I believe very strongly will consider anything you propose to suppress. Then 3 days later, on July 28th, Ms. Morrissey said there was not a second extraction. Actually, the original extraction was December 8th. I then had a follow-up I sent to California. Okay, that's what I'm talking about with the July 12th. Well, then the entire 18,000 pages gets disclosed without any filter or any review or any steps taken by the government to ensure there's no attorney-client. Ms. Morrissey then later, when she finds that out, instructs her California expert to go through and do that filter and to exclude those attorney-client communications. So it was a very easy step that could have been done, but it was not done. So they don't do the IPRA review. And then the real egregious part of this, Your Honor, one is that our attorney-client communications are invaded, but two, they have now turned these over to the chief adverse witness to Miss Gutierrez-Reed. The 18,000 pages, including Miss Gutierrez-Reed communications with friends, her text with family members, her text with me, any text on that phone that they extracted, which was a full extraction of her phone, went to Seth Kenney. So Seth Kenney is the individual who was the chief ammunition supplier to the Russ set, and that we will have evidence at trial that most likely Mr. Kenney was the one who supplied the live rounds, which ended up on set. So now the chief person, the other person that could have supplied those live rounds, he's got all of our communications. He's got all of Miss Gutierrez-Reed's personal and private communications. And so what we have seen here, Your Honor, is that the fact-finding process has been corrupted. Not only the idea of an attorney-client should never be invaded, it should never be something that we worry about the government seeing, but I've never seen a prosecutor supply the chief adverse witness internal communications of the defendant, let alone the defendant and her attorney, because we want under the rule of exclusion, under Rule 615, for witnesses to testify to their own memory, to testify to their own observations. That's the whole point of that rule. Well, now we have an individual who's supposed to be key to this trial, who has all of our communications and can't testify anymore from his memory and his own impressions, and he's tainted. So the further taint of that is Ms. Morrissey has had communications with them. Seth Kenney has had communications with the government from the get-go. He was in the sheriff's office day one, making calls to try to find out where the live rounds came from. He had many, many calls with the sheriff detective. He has had many calls with Ms. Morrissey. This call that generated the alleged IPRA thing was July 11th. And all of a sudden, the next day, Seth Kenney's asking Ms. Morrissey for an IPRA the day after he talks to her about text. And then he gets all 18,000 texts. And now we have to go into a trial where the chief adverse witness has seen all of these. The problem, Your Honor, is that they took no steps, which would have been super easy to just filter them out. To just say, in a phone of this size, an extraction of this size, with a client who lives in another state, there's got to be some communication with her attorney. Now, Ms. Morrissey says that no attorney would ever communicate with her client over.
No, not 18,000 texts, 18,000 pages.
For a phone. That happens. It happens when you're in court, when you're not able to talk to the person. You can't return calls 16 hours a day to clients. Those communications happen. That's beside the point. Again, it's an attempt by the government to deflect what they did and blame us, because you never expect as an attorney, it's never happened to me in 30 years, that the government's going to be privy to your communications with your client, is going to seize them and look at them and give them to a witness. Now, I'm not saying Ms. Morrissey and Mr. Lewis looked at them. They asserted they did not. I don't know that one way or another, but that's what the word they've given, that they did not look at them. But what they did say is they sent him to Seth Kenney, who had him for 12 days. And I believe he looked at him. He had all of those communications for that time frame. So they didn't take any steps to shield those. Now, the two cases we've cited to the court, the Robinson case out of Delaware, there was a paralegal who obtained communications from a defendant and his lawyer, seized from his cell. She read those, wasn't instructed not to read the attorney-client. The Delaware court ends up dismissing, finding a Sixth Amendment violation of effective assistance of counsel because she was part of the team. In essence, Seth Kenney is the same situation. He's been part of the government team from the very first day of this case, trying to direct what they were looking at, what they were doing, and now their new theory that Ms. Gutierrez-Reed brought live rounds on set. This is a new theory that Ms. Morrissey's had in the last couple of months. This was after the attorney-client went to Seth Kenney that this theory comes up. The other case, Your Honor, is Schillinger versus Hayworth, and we cited from the 10th Circuit. That case, the 10th Circuit reverses for a new trial on an attorney-client violation when a sheriff's deputy is present for court prep session with the defendant and his lawyer. He then tells the prosecutor about these prep sessions, and that comes out, so it's a violation. Well, the court there reversed and ordered a new trial. Ordinarily, when we have a certain situation like this, Your Honor, the remedy is to suppress the witness who got the communications. If the prosecutors have had communication, to recuse those prosecutors. Now here they say they never reviewed them. but we do know they've talked to Mr. Kenny. And the problem, as we detail in our pleadings, is Seth Kenny has important information for both sides. So he's now corrupted, but he has information. For example, right after the shooting, Sarah Zachary called him. She sent him a text emergency. She called him. They spoke for a couple of minutes, and then she threw rounds away. She got rid of rounds. And we've got to ask him, we've got to ask her about that. He's got other important testimony for both sides, but he's now been tainted to the point on a fundamental fairness. How can a defendant have a fair trial when a chief adverse witness has all of the attorney-client text? And finally, Your Honor, I want to get to the waiver idea. And we've gone through this on how inconsistent it is with Ms. Morrissey's communications right after this happened. It's also inconsistent with how Sheriff Hancock treated it. She did not load any attorney-client communications, and there's no express waiver. An important constitutional waiver, as this court knows, Miranda rights, any type of preliminary hearing, any type of thing like this has to be expressly waived by the client. She never did that. She never signed anything. We never waived that. We had the communications. We're not opening our attorney-client communications.
That's why you wear hats.
That was understood. It was also understood this would be limited to the Rust time frame, which Detective Hancock kept her word. She was very professional about how she handled this. Then Ms. Morrissey, who claimed she read emails and didn't see a limitation.
Solidarity for the defense.
She sent those to Seth Kenny on July 12th. The emails from Hancock to Ms. Morrissey were dated July 18th, 6 days later. So there's no way Ms. Morrissey read those emails prior to sending them to Seth Kenny. She didn't take any steps to protect or to do a filter or to make sure we had a fair trial. Ms. Gutierrez-Reed had a fair trial, not had the chief adverse witness reading her communications with me. So that is the basis for our motion, Your Honor, that suppression is not in and of itself. In a normal case, it would be, but here it's not. Because of the intertwining and the various parts of testimony Seth Kenny would give, we can't have a fair trial because of that, because of what's happened.
Ms. Morrissey.
Your Honor.
Okay. I agree with him. From what he said, the way he presented it, I agree with him. The state better have a damn good argument on this point. Because I agree with him.
If it's all right, I'm going to respond on behalf of the state.
Okay, thank you. Thank you.
Thank you. Your Honor, the state must be allowed to rely upon the signed written waivers that are executed by defendants and their lawyers. In this case, we have a signed document, a consent to search authorization form that was executed on December 7th, and it's signed by both Mr. Bowles and Ms. Gutierrez, although Ms. Gutierrez's signature appears to be signed by Mr. Bowles. But regardless, both parties have agreed to a consent to search authorization. And I think the consent to search authorization language is important here. And if you don't mind, I'd like to read a little bit of this. The consent to search authorization form says that before any search is made, you must understand what your rights are. You may refuse to consent to search and demand that a search warrant be obtained prior to any search described below. If you do consent to a search, anything of evidentiary value seized in the course of the search can and may be introduced into evidence in a court of law against you.
Oops.
The second page goes on to say,
Shit.
I authorize the deputies and detectives of the Santa Fe County Sheriff's Office to seize any article of questionable nature or contraband from my vehicle / residence / property or any items that may be deemed to be of evidentiary value. By signing below, I am providing written consent / permission for the above named deputy or detective or their designees to conduct the search without obtaining a warrant and to seize any evidence outlined above. I give consent / permission freely and voluntarily without threats or promises or of any kind, either express or implied, made to someone close to me to convince me to grant consent or permission or to search the property described above. This document was emailed by Corporal Hancock, and he had as much time as he wanted to review this document, to read it, to understand it, and to go over it with Ms. Gutierrez. If they had wanted any limitations on the scope of the search, they could have been written on the form. There is a section on the form for additional notes. They didn't do that. Essentially, what has happened is Mr. Bowles has relied upon verbal statements to Corporal Hancock, and she did follow them. I just want to be clear for the record. Corporal Hancock does acknowledge that Mr. Bowles asked her to exclude attorney-client communications from the search that she performed. But that wasn't communicated to the state. When Ms. Morrissey and I entered into this case, we received a copy of the form. And as agents of the state, we are allowed to rely upon that form. If anybody who looks at this form is required to think, wow, I wonder if there are any side promises, side agreements that have been made here, I better call everybody who signed this and ask them whether some secret side deals have been made, that would invalidate the entire reason that we have these authorization to search forms to begin with.
Well, shit.
So,
yeah, he's making the one argument that I think saves the state's ass on this. Giving consent. See, just giving consent to search your phone doesn't mean you waive the privilege, the attorney-client privilege. But when you agree that anything of evidentiary value found on that phone can be used as evidence against you,
Fuck.
And the other thing is we didn't seize this phone. All of the cases that Mr. Bowles cited earlier, the 10th Circuit case, those are instances where the state affirmatively seized the phone. That's not what happened here. The phone was voluntarily turned over to the state, and we conducted a search that was in accordance with the document that the defendant signed. We didn't do anything that was not allowed in this waiver that she executed. With regard to some of these other arguments, Your Honor, I think the timing is really important for the court to understand. The disclosure of the attorney-client privilege communications happened in July. It wasn't until just about a few weeks ago that the defense started making an issue about this. They waited over 6 months to bring this to the court's attention or to ask us to make any sort of accommodations concerning these text messages. Even though they didn't ask us, when we found out that that this report contained attorney-client information, we immediately notified them. We immediately went to Mr. Kinney and we said, you have got to delete that report that we provided you. He said he agreed in writing to delete it. He did, however, provide a copy to his attorney. I don't know, Your Honor, whether his attorney kept a copy of the report. We asked not to be copied on any of the transmissions or communications between Mr. Kinney's lawyer and the court because we didn't want to come in contact with that document again inadvertently. So based on what Mr. Bowles is saying, it sounds like the court did receive a copy of the report. But Mr. Kinney himself indicated that he deleted it as soon as we asked him to. Regardless, by waiting 6 months to ask for relief from the court now in the form of excluding Mr. Kinney as a witness, well, they've waited too long. You know, the state has been working with Mr. Kinney and with all of the witnesses that we expect to call. And so for us to lose out on that because they have waited 6 months to raise this issue seems unfair. The other thing, Your Honor, that I would like the court to know is that the defense treated this report with just a lackadaisical approach.
Yep.
When we informed the defendants that this report existed and was on their defense server, we asked them, would you please give us permission to delete this report from the defense server? And the reason is because at that time, there were quite a few people who had access to that, including Mr. Baldwin's attorneys. And so we didn't want that report to continue to be distributed. They acknowledged, it was either Mr. Bowles or Mr. Bullion acknowledged our message and then never responded further. So about a month later, on August 25th, we sent a second email and we said, would you please give us permission to delete this from the defense server? And finally, at that point in time, they gave us permission to have it deleted. So, it is not the state's responsibility to protect the attorney-client communications between Mr. Bowles and Ms. Gutierrez. That's Mr. Bowles' job. That's Mr. Bullion's job. We did not do anything wrong. We relied upon a completely and validly executed authorization to search. And if this court were to rule that prosecutors can't rely on these written search forms, then they would just be of no use and value in any case going forward. Thank you, Your Honor.
Damn it, he's right. he's absolutely right. That was a very comprehensive waiver she signed, and her lawyer sat on it. Damn it, that sucks. If you're Hannah, that sucks. You did something stupid, girl. Your lawyer did something stupid by allowing you to do something stupid. He did something stupid too. Apparently there are ways to sign. Yeah, you go, no, you can download it, but we're not waiving anything. I mean, you can say, yeah, we'll agree to let you do a file dump on the phone, but that's subject to attorney-client privilege, and you will not be allowed to use anything of attorney-client privilege you find on that phone. I mean, make sure that's in the agreement, but best thing to do is to wait for the warrant. Oh, that's ungood. And the DCV Titan talking about Mr. Bowles' head. How does a convex surface both reflect and magnify? I don't know. It defies physics. Oh no. And Jennifer says this guts attorney-client privilege, dirty tricks. No, it's not dirty tricks. That's not dirty tricks. That is just him going, hey, here, sign this and let it in. If you agree, that means everything on here we get to use. That's straightforward. There's nothing dirty trickish about that. It was stupid to sign it. That's all it was. It was stupid to sign it, stupid to do it, and really, really stupid of her lawyer, as he said, to take such a lackadaisical approach to it and just rely on some oral promise that was made to somebody else, not them. Even if she read it, you still have to understand and appreciate what it means. And the average layperson that reads that is not going to understand what waiving attorney-client privilege means. Sorry, that wasn't it. Yeah, well, Mustang McCracken says, I mean, it kind of is. There was a verbal agreement between the lawyer and the person he signed it with that the state can just back out of. Well, amazing. You didn't agree with us on that. And as he said, I can't go through everybody and call up everybody. Go, okay, is there some secret agreement I don't know about? It's the document. The document is the important thing, not off the document discussions. That, you know, they call it like the four corners of a contract, or everything within the four corners is everything. If it ain't in there, it didn't happen. This promise was not in that document. So as far as the prosecution is concerned, it didn't happen. Yeah, I mean, you can even understand it, but appreciate it. You know, you have to appreciate what the words mean, and that's what lawyers are for. And her attorney definitely should have known that. He should not have just relied on something that he agreed to with another lawyer. I hate it, but he's right. I hate it.
Thank you, Mr. Lewis. Reply, Mr. Bowles.
Yes, Your Honor. It's stunning to hear them say that they don't feel like there was anything done wrong when the first email we got from Miss Morrissey indicated she does take the attorney-client privilege seriously and will consider anything you propose to suppress the communications. So either the government can live by their word or they cannot. So their first response, Your Honor, was that we will suppress these. We will agree to your proposal to get you to suppress. This is the first I've heard that all other people in Baldwin's attorneys had access to that defense server. We were told that this was a defense server for RK. I didn't realize that other people now may have seen our attorney-client. So I thought these were sitting on a defense server with us having only the access to them. So there wasn't a dire need to get them deleted right away. This is the first I've heard just right now that Mr. Baldwin's attorneys and others had access to our attorney-client information. So that's actually another shocking thing that I didn't realize. The reason why this took a while is because we did not get their new theory and realize the gravity of the harm that this had caused until a month or two ago, when they indicated that there was this new theory that Hannah had brought these, Ms. Gutierrez-Reed had brought the live rounds to set and had these pictures and various things. And we realized Seth Kenney had communications with them, and these attorney-client communications had been reviewed, was our belief, by Mr. Kenney, not by Mr. Lewis and Ms. Morrissey. They've said they didn't. So that's, again, so, Your Honor, the initial thing was not a secret side deal. This was a promise by the government, by Detective Hancock to me, which I took her at her word, and she kept it. She did not get into attorney-client communications, and they are bound by that. The prosecutors are bound by that, and we cited cases on that they're a team, and that's in the Brady context and others. They're held to that knowledge. It's not just that you get a form and say, oh, we can't interview everybody in a secret side deal. Call Detective Hancock. It's really easy. And ask her, you only did a 1,000-page report. There's 18,000 pages. Were there limitations on this search? That should have been a tip-off to an experienced attorney. There's all kinds of stuff in here. We better.
Well, if you're an experienced attorney with 30 years experience, you should know better. You should know better. And say, well, why didn't he just call the detective? Again, that goes back to his argument. What am I supposed to call everybody? How does he know there's this agreement with the detective? Unless he calls the detective, and why would he just call the detective? He would call everybody. So yeah. I shoot ropes. Thoughts, Jeff, on what? Thoughts on what?
We better run something.
I have lots of thoughts.
They didn't do that on attorney-client on a filter. They didn't do it on IPRA on a filter, which is also required. So to say that this is all, we have to safeguard them. No, the government has a duty not to invade the attorney-client privilege of a defendant.
Well, you have a duty not to let them.
And that's cavalier, that's reckless, and that's absolutely nothing I've ever seen in 30 years. And it's denying Ms. Gutierrez-Reed a fair trial.
You let it happen.
Your Honor, may I just make one point clear? Just 10 seconds.
Yes. Yes.
Your Honor, I just want to be clear. We are not intending to use any of these messages at trial. I just want the court to understand that. We're not proposing to use anything from this report between Mr. Bowles and Ms. Gutierrez at all.
Thank you. The court makes the following ruling. First of all, that consent to search is what controls.
Yeah.
These text messages about talk to Hannah, she just wants to make sure her private photos are not given away. And yeah, I'll keep it to the Rust time frame. Very casual. I'm not sure when. Now I've heard that the state agrees that Mr. Bowles did say, I need the attorney-client also, and she said, okay, that could have been before, after. It doesn't matter to the court, because what's controlling is that consent to search authorization. You have absolute opportunity. That is what you use. She sent it to you. You were able to read it ahead of time. You're saying that Ms. Gutierrez didn't waive anything? She sure did. Her signature's on it.
Yep.
And to reiterate,
Yep.
if you consent to a search, anything of evidentiary value seized in the course of search can and may be introduced into evidence. I give consent permission freely and voluntarily without threats, promises of any kind, either express or implied, made to me or someone close. You're telling them that she promised you. She gave her word. This is saying no. This would have been your opportunity to have put it in. This IPRA is, I'm not going to get an IPRA trial in here. The inspection of public records says every person has a right to inspect public records of this state, except certain types of information, including attorney-client privileged information. In this manner, the statute gives the public the right to access information, except where the right doesn't exist. However, critically, in the IPRA statute, it doesn't forbid the state to disclose information that the public does not have the right to access. It merely protects the state from being compelled to do it. IPRA acts as a shield from compelled disclosure. It's not a sword to attack the government when it decides to disclose in spite of IPRA's protections. The timeline is you put no restriction on it, and it falls under IPRA. You're saying that they had a duty to do attorney-client? That was on you. How are they going to know what's attorney-client, what's waived? Just because you have text message, or they're going to say, oh, there was no waiver? They have to refer to the consent form. Third, I did do the in-camera review, and I find that the communications are not materially prejudiced.
Michelle says she gave consent, but also has the right to revoke. I think you meant the right to revoke that. I didn't know. You don't have the right to revoke the consent after they do what you gave them to consent to do, and you don't like what they found. You don't get to go, oh, just kidding. I revoke my consent. Unfortunately.
Prejudicial to the defendant or defendant's trial strategy.
You're muted, Judge. At least I hope it's you.
Your Honor,
How long have I been on mute?
Oh, good.
about 30 seconds.
Okay. So what I'm saying is,
Boomer!
I did conduct the in-camera review. Okay. And it talked about public relations with respect to the media. That's what was in there. It was media information. What was said in the media, how to respond to this, things like that. The state's decision to share the 18,000-page report with a state's witness before reviewing its contents, questionable as to why we didn't do that. But when she says that she respects the attorney-client privilege, that doesn't mean that she violated any duty. The consent to search authorization should have been negotiated and drafted to exclude the attorney-client privilege.
Absolutely.
I'm denying the motion. Mr. Lewis, prepare that order.
That's what I said.
Judge, I would ask the court if this court would include interlock appeal language in that order.
You're allowed to appeal anything, but not before trial.
And I'm just asking on the interlocutory appeal language.
Uh-huh.
That this court include that in the order.
No.
Okay, then we have to consider a writ, and I just want to alert the court to that.
All right.
Okay.
Yeah, go ahead.
All right, now we're going to move over to,
Wow, that was bad. Dang.
Ms. Morrissey talked about the motion in limine. I mean, the prior bad acts notice. There's been no motion in limine for me to consider. So there's nothing before me today on the prior bad acts. Now we're going to move over to.
Whoa. Okay, that's interesting. Why didn't we have a motion on that? They want to exclude her prior bad acts, the other bad things she's done. Perhaps her previous. She had a little bit of an incident on a movie set with Nick Cage, where there was some shenanigans. There was some live fire going on there, I believe is what it was. But maybe that's what they're talking about, but probably not, because she wasn't convicted or charged with anything. But there's alcohol abuse, maybe there's some alcohol related charges or something, or drug related charges or something. But prior bad acts, they want you can't generally you can't use prior bad acts to show and prove that you did this bad act. Just because you've robbed a house doesn't mean that you robbed this house. But there are exceptions if it shows a modus operandi, if it shows a pattern of behavior, if it shows you have knowledge of doing because of what you did before, that shows you have knowledge to do the current bad act. There are ways around it, but I guess the judge was expecting the defense to submit a motion to limit references to prior bad acts, but they didn't. They didn't submit the motion, so she's like, I got nothing to limit. So maybe they're going to file another one real quick. I don't know.
And I'm going to address these now because I do not have blocks of time in my schedule before the jury selection.
That's what I was
so
into her.
We've got
her ex's
2 late witnesses,
accident.
And we've got a voir dire request. Let me just address the voir dire request. You're entitled to voir dire.
And it's either voir dire or voir dire. I've never heard voir dire before. She's like she's combining both. She has some weird pronunciation.
I don't see why that would be a problem. So,
thank you, Your Honor.
Do you oppose that, Mr. Bowles, or do you recognize it?
No, I think that's totally appropriate to.
Okay.
I don't oppose that.
To voir dire the experts outside the presence of the jury.
Yes, absolutely.
Thank
Okay.
you.
All right, now let's go to these this late disclosure of an expert and of a packed witness. Mr. Bowles, let me hear from you why this is happening.
Yes, Your Honor. So Lenny Callis is a female armor on the East Coast who contacted us very recently, within the last 10 days. We didn't know anything about her. She reached out to me by email and said she felt like she had very material information, including with regard to union and requirements of union, which Ms. Gutierrez-Reed was not. Her experience as an armorer and expert testimony generally related to that. We had to call her and vet her as to what she would say, get her CV, and then we sent that to the state. Now, this was not something we didn't know about her till within the last 10 days. So that's why this came out late, Your Honor. We immediately by email said she would do a pretrial interview any day on an hour's notice. She's indicated she's available any day, including the weekend. She will do a pretrial interview. Alternatively, I mean, if and no one wants to continue the trial, but we would agree to that as a remedy.
Too late. There's no way. They're way too close.
Instead of exclusion of a witness who just came to us. And the other thing that's been hard, Your Honor, we don't have the resources of the state. Ms. Gutierrez-Reed doesn't have a special appropriation. We've had to find experts who have agreed to assist without compensation. And that's been another very, very difficult thing in the defense of Ms. Gutierrez-Reed. And she came forward in the last 10 days. That's what happened.
What is she going to testify to?
She's going to testify that as a union armorer, you are trained in certain requirements.
Hannah wasn't a
You
union
are also
member.
certified in certain things. Ms. Gutierrez-Reed was not. union. She had applied to the union, but she was not yet union, and so she cannot be held to the standard of some of the things that the prosecution is mentioning because she's not union. She's also going to testify with regard to the live or to placing the rounds in the firearm when on a very busy movie set, that this is a mistake that could be made, especially because dummies and live rounds, they look like each other. They can be confused. And when you're rushed and you're being yelled into your ear to get something done, this is a mistake that can happen. She's also going to testify to, in general, you should not have two roles as an armor on a gun heavy set, which the state's expert was going to testify to too. Carpenter said the same thing. She was a props assistant and an armor. So she's going to reiterate that this was
if one person's going to say you don't need another person.
Gutierrez-Reed did not have the adequate resources, was required to do two jobs, and mistakes can happen. That's essentially what she would testify to.
Response on that one, not the fact witness. This one.
Your Honor, the defense has had years to get a professional armorer to be their expert. They have had years to do it. In fact, we have a professional armorer who has been on the witness list since day one. The defense has always understood that what they needed to do was try to get their own expert. It's absolutely not fair for them to spring an expert on us a week before trial when they've been on notice that they needed to do this the entire time. And look, I'm not unsympathetic to the fact that Ms. Gutierrez has limited resources, but I also understand that if you have limited resources, you go to the public defender and they have the resources to hire all of those experts. So the fact that she hired lawyers who are without resources to do this just means that they should have told her, you need to go to the public defender's office because we don't have those resources. This is crazy that for 2 years they act like we didn't know this lady existed. She just called us. They knew that having a professional armorer as an expert witness was something they probably should have done, and they just didn't do it for years. And now here we are a week before trial. In order for any of this to work, she has to be interviewed. Her interview has to be transcribed. We have to sit with our expert and go through it. There's all kinds of preparation that has to take place, and we simply don't have the time to do it. We're getting ready to do a trial where we're calling like 30 witnesses. We can't carve out the next week to try to solve the mistake and the problem that Mr. Bowles and Mr. Bullion made when they didn't go look for an expert for years. It's absolutely outrageous. We would absolutely ask the court to exclude this person. This person needed to be there, I mean, at least 6 months ago.
Oh my God, the voice. I know you guys are talking about it. I don't like to talk about voices, but it's I was literally like when she was in the throes of passion there. It literally set my teeth on edge. It literally felt like I was chewing aluminum foil. This is a shrill shriek. And I want to, and I hope this is the case. I hope this is the case that she's just being extra shouty because she's on a Google Meet thing remote, and she thinks she has to yell really loud to have her voice heard. I hope she's not this way at trial, because this is shrill and grating and unnecessarily. She's not being angry and confrontational, but it really sounds like she is. Yeah, she's not. See, that's the thing, is like the whiny ass. She's not really being whiny. If you just think of what she says, but you run it through your head in a neutral voice, they're good arguments. They're good arguments. They make sense. They're not whiny, but it's just her delivery. it's just grating. The DCV Titan with a Canadian $5 super chat. Thank you so much, DCV Titan. So because she's not union, she doesn't have to follow safety regulations. Not saying how that works. Yeah, he was just arguing that union members are held to the union rules, and she wasn't there, so she doesn't have to do everything that the union people have to do. Kind of a lame argument, I think. But bye, Franz. Baldwin is paying for this attorney thing. No. If anybody's letting Baldwin pay for this, they're insane. Because if her lawyer's any good, one of his arguments is going to be, it's not my client, it was Baldwin. Baldwin should have sole responsibility for this because he was the one that he was the one that ignored the training. He was the one that was condescending. He was the one that didn't want to talk to anybody about it. He was the one that pointed the gun. He was the one that pointed the trigger. If the lawyer's worth anything, that's going to be part of their argument, is that it's Baldwin's fault, not hers. And and then that too. Baldwin's throwing her ass under the bus again, as he rightly should, as his lawyer rightly should say, no, it was all on her. I'm just an unfrozen caveman lawyer. I don't know. I'm just an unfrozen caveman actor. I don't know anything about gun safety. It was her responsibility. Yeah, no, they're at opposite points on this. They're going to desperately try to throw each other under the bus to avoid their own responsibility. So there's no way he's paying for her.
I couldn't even believe it when we got a supplemental witness list. And listen, I also want you to know, Judge, these guys didn't reach out to us and say, hey,
I thought she was done.
We just found out about this lady. Let's talk about this. How do we find out that this is happening? They just send us a copy of a supplemental witness list. They didn't take they never have come to us and said, hey, we'd like to move to continue the trial. If they want to move to continue the trial, they can file an opposed motion to continue and the court can decide how to handle it. Thank you, Your Honor.
Oh, nice to meet you, Mrs. Hello, my kid's from a sperm bank, since I can't keep a man because in addition to my jillion neuroses, I have a weird looking vagina.
Mr. Bowles.
Judge, that's actually not true. We emailed the state and let them know about this new witness that had contacted us. That's absolutely 100% not true. Ms. Morrissey knows that. We actually did look for experts, and that's what I tried to convey to the court, that we did look for experts. We were not able to find that type of expert. We found others until Lenny Callis contacted us. And that's how and in the last 10 days, we got her information. Now, we told them that. We emailed them about Miss Callis, and we emailed her CV, and we said, we'll have a PTI anytime. This is no surprise what she's going to testify to, because their armor has virtually the same testimony, except for the union part. That's the only part that's different.
Silent PS says she's like the tits and ass girl from Chorus Line, Dance 10, Looks 3. I hate myself that I know what you're talking about. I hate that I know what you're talking about. I hate myself because way back in the day, back in high school days, the old Larex may or may not have been in a production of a Chorus Line. May or may not have been. I'm not saying.
Different. Mr. Carpenter essentially says the same thing that I've seen. So, Judge, we were diligent. We did try to find experts throughout this, and she came to us at the very end. That's what happened. That's the facts.
Let me respond. When you're telling me that you emailed them pretty much that day, if I'm not mistaken. Where's that? The email is, I mean, that's misleading to say that they had time, because the email was right then and there when you did your disclosure of witnesses. You just attached it to your disclosure to let me know that you had reached out to them. Not sufficient time. I'm denying the motion on this basis. Number one, it's late. It's too late. I'm not going to continue the trial. Do not ask.
Yeah, you don't get things like this in a week, 10 days before the trial. You don't get to, when you're 10 days out, there's no way the trial is going to be delayed.
me. No one asked me for a motion. I'm telling you right now, I'm not continuing the trial. Secondly, this thing about the only difference that she's going to do is about the union duties. Fine. They can stipulate that she's not union. You know, you can cross-examine about what, you know, do you know what union does? And the fact that she reached out to you tells
Weird.
me that
She wants
that
fame.
this is not prejudicial to you. You didn't go seek her out. You didn't think that she reached out to you.
She's a fame.
And the
whore.
other thing is it is unfair to the state. Exactly what Ms. Morrissey said. They'd have to do this, they'd have to do that, and there may be a continuance. There may have been a continuance because they would have needed more time, but they're not going to need more time because I'm denying that expert. All right, next up is the fact witness.
Your Honor, with regard to the fact witness, the state amended their witness list, I want to say about a month ago, and we didn't make a big stink over it, even though it was pretty close to trial.
You said the state amended. You said the state amended.
I'm sorry, I apologize, Your Honor. The defense amended
All right, that makes sense.
their witness list, and they added a fact witness, and they indicated that they would schedule a pretrial interview with this witness. And I followed up with them a couple of times saying, you know, we need to get this interview done because we're coming up on trial. They have never provided an interview with this witness. His name is Zach Sneesby. He was a member of the crew. They knew of
his name is not Zach Sneesby. Nobody's named Sneesby. I'm calling BS on that. There is literally nobody on earth that is named Sneesby. But I hope there is. I'd tell you what, if I ever get another dog, gonna name it Sneesby.
About this person the entire time. He's on the call sheet. Everybody knew about Sneesby. Everybody knew everybody who was on the crew. So they haven't provided him they haven't provided us with a pretrial interview, and we're asking that he be excluded. I don't know why they haven't been able to set him for an interview, but
do it.
It's too late now.
Exclude him. You're right.
Mr. Bowles.
Judge, and once again, Miss Morrissey's known about him the whole time. The state interviewed him early on. But here's the thing. She just said, we haven't been able to reach him. We've reached out multiple times and he hasn't gotten back to us. So we agree. If he's not going to submit to a pretrial interview, then he can't be a witness.
All right, there you go. They're losing a
but
witness.
the idea that they didn't know, they've known about him the whole time too. He was interviewed by the state or by the officers, but we're not going to call him.
All right. Solve that problem.
All right, that takes care of that one.
Yep.
Okay, so
It does.
I need an order from the state on the late disclosure of experts. Have I missed anything?
I don't believe so, Your Honor.
Okay.
And Judge, we intend to also submit an offer of proof on a detail to what she would testify to. And I want to make that part of the record.
Are you going to do it now?
I can't do it now. I need to get it from her and I'll submit it in writing.
All right, well, we'll note that you don't know what you put her down and you don't know what she's going to testify to.
No, Judge, I told you the outlines of it, but I want to make sure I'm clear in the record. So I do know the outlines and I did indicate that to the court, but I want to have a clear record.
Okay, well, the clear record for me is that you only outlined, but that does, if you're going to put all this information in after the fact on my ruling, which is related to what you've given the court, that's fine. All right, thank you. We're in recess.
Oh, hey, what's up, Hannah? We had a Hannah sighting. Let's see how Hannah's doing here. Hey, Hannah, what's up? Got herself looks like she's got herself new glasses. Hair's done. She's looking okay. Looking better than she was on the day of the murder. Or I'm sorry, the day of the death. Phrasing. What's up, Hannah? All right. That looks like that is it. Let me do this here. Boop. Right, folks. Yeah, that was grim. And we'll be seeing that again if we watch the interrogation. If any of you saw, it's like, Oh, that was really, really bad. They pulled her into the police station for her interrogation, and yeah, while the police were out of the room, you know how they leave them sitting there to stew a little bit. The police walk out, they're gone a little bit, and then she kind of, it was kind of nasty. It was kind of nasty to watch her sniff her own pits in the police station. I forgot about that. Thank you for bringing that back to my memory. Things that were unseen have now been recalled. They are unseen no more. Well, Strawberry Yoda, you guys continue your sleep there. We're gonna pull you off cam here for just a second. All right. Wow. Okay. Takeaways. The prosecutor, she's got to do something about that voice. She's got to do something about it. Let the other dude talk. The other dude was actually, I enjoyed listening to him. I hate everything about her delivery. I hate everything about her speech pattern. I hate everything about her voice. Again, I just want to think she felt the need to be shouty because she was on a laptop in a Google Meet. I hope that's it. I hope when she shows up in court, she's going to be talking normally, calmly, without the screech and ree and sneed in her voice. Yeah, she's exactly, Bush. She's way too forceful and ree. Yeah, I hope it's just because of the situation. We'll see. Well, next week we'll find out. We'll find out if that's her natural thing or if, or if that's it. We'll see. So that's her. I like the other prosecutor guy. I like Mr. Bowles. He does need to kind of dim the lights on the forehead a bit, but that's just, that's something baby powder can clear up. Just put a little baby powder on the noggin. I liked his art. He didn't have much to work with, but he made a huge mistake on that waiver. Huge mistake. But I mean, he was making the best arguments he could. They were wrong for the most part, but he was making the arguments. Now the judge, I like this judge. I like this judge a lot. She commands her courtroom. She controls it. She didn't take shit from either side. She held people. She made quick decisions. She made very reasonable, rational decisions. I like this judge. She's not going to let this thing get out of hand. She's gonna control it. She's gonna keep it on track. So good for her. I really do like the judge. And with that, it's Friday. Damn, Jeff, that is a chair. Papa Hemingway from Ethan Allen. No, this is just it's a buffalo hide Chesterfield. Got some nice cushy arms. Two of these are in my whiskey room, my whiskey and smoke room. So my regular chair died, and I'm waiting for another one to be sent from China. It's because it was a cool chair. And it served its purpose, and it didn't have damn wheels on it. I literally have to order a studio chair without wheels from China because there isn't one available here. But so I just pulled in one of the Chesterfields from the whiskey room, and it's way too comfortable. I could just snooze out here. There's no way I can do a trial sitting on this chair. I will fall asleep because this is my whiskey and reading and smoking chairs. So yeah, it's just a temporary thing. It takes up way too much real estate in the room. There's, like I said, there's about this much space between the back of the chair and the table back there. So yeah, that's this isn't, I wish it would be a permanent fixture because I like it. This is comfortable as hell. But yeah, it's got to go back in the whiskey room. The whiskey room just looks weird with only one chair in it now. It looks lonely and sad. Buffalo Hide, why don't you sit down tonight? Sit down tonight. Sit down. Good night. That's a good one. Mary, we're right here in Bedford Falls. Important question. Does it have an ottoman? No, I had the option of ordering an ottoman with it, but I didn't. because it was expensive, and I don't really. I have an old Ottoman, but I just didn't think I needed to go to the expense of getting another one. But yeah, this is the chair in and of itself is great. I can just put up my feet on the other old Ottoman, but it is an important question. Thank you. We're done. We're done, folks. It's now 1:15 a.m. Saturday morning. I'm going to head off to Seoul and do some drinking for the next 48 hours. I'm going to go to sleep, wake up, head off to Seoul, meet up some peeps there, hit some bars. I'm going to go to some amazing. There's a not that anybody cares, but I got some time to kill. You can take off now if you want. Oh, let's make sure we wrap everything up here first. We got 200 viewers still sticking around. Let's find a place to send you. Where are we going to send you? We got 243 likes. Thank you so much for that. We got a great deal of support. Appreciate all of that. Oh, we do have one super chat. Titan, thank you. You've been very generous tonight. Thank you so much for that. The DCV Titan with the $5 Canadian says we couldn't find an expert armorer, but there's a union of them. That certainly says a lot. Yeah. We don't want to have anything to do with this case. That's kind of what it says. Or they're just asking too much money that you can't afford to pay. Let's find someone to send. Then we can chit chat for a little bit. Let you know what's up. We'll give you the weekend preview in case you've missed it the 2 times we did it. Let's see. Go to my studio, YouTube studio. Go to content. Live. Details. Customization. Redirect. Who's going to get the redirect here? What do we got going? Good Logic. Uncivil. I think we'll go to good Logic. We'll send you all. We haven't done a Joe send off in quite a while, so we'll send you over to Joe. All right, that's all locked and loaded. We'll be heading over to Good Logic after we ramble for a bit here. I can't even remember what I was going to ramble about, so we'll just tell you what's up. What we've got here coming up. I'm gonna head off to Seoul. Like I said, have a good weekend, having some drinks. This is with a very, very dear friend, so we're gonna kind of go all out. There's an Italian restaurant called Brera in Seoul that is an honorable mention for a Michelin star restaurant. So it's really, really good, really good food for a reasonable price with huge portions. And it's actual real Italians running it. So that's great. Do that. Then we're going to go over to the it was ranked the 18th best bar in the world. Going to go there for drinks. That's a way swanky place. I mean, you have to pay like $40 to just get a reservation. It's shit, but hey, you get some of the best cocktails on planet Earth. And then we're going to head over to the Four Seasons Hotel for a bar called Charles H., which is one of my favorite bars in the world. It used to be ranked, I think it got up to about 32 or 38 best bar in the world. Yeah, that's we're going to go there, and their cocktails are insane. So we're going to do that. That's all we're doing. Then I'll come back on Sunday afternoon. Monday, we'll hope to have a Maritime Monday for you. Tuesday, kind of up in the air right now. Wednesday is either going to be the day 1 of the trial, or Hannah Gutierrez reads a police interrogation video, and then we'll start. If they do a second day of jury selection, we'll do OJ. Then we'll just kind of keep playing it by ear until they actually start. That's what's coming up for the foreseeable future. Plus, next Friday is the Fuck It Friday, where we say fuck it, and we have a great panel of guests. I grift hard once a month, so we don't have to do it the rest of the month. We just you throw your money at me, and every $100 we do shots of booze, and we get lit and have a good time with our guests. I got to send out invites for that. I haven't done that yet. Damn. All right, so let's do that. And Jennifer says, have I missed the unboxing? There's a couple of unboxings that are going to happen. One of them is not going to happen for a very long time. There's some stuff from somebody being sent from the States. That should be here Monday, I think. Or is it from the UK? I don't have to check. I think UK. I think. But there is one box that I know has Joe Choi, and I believe, Jennifer, There's something that it says it's like a ceramic statuette. That was how it was on the invoice list. That has been a saga. It took about a month and a half to get it shipped from the UK. It arrived here in Korea, but there's invoicing problems they knew about before they sent it, and it got here, and customs said the invoices doesn't seem to match what's inside. So next week they're sending it back to the UK. And then it's going to get back to the mailbox people. They're going to look at it, redo the invoice, reach out to me, and then hopefully resend it back to Korea. So that's going to take 2 or 3 more weeks for that stuff to get here. But whatever's coming on Monday, we'll do that on Monday. The one that's coming from the UK that has been there since the end of last year is just a pain in the ass, and it's just getting hung up with customs and back and forth. It's a mess. All right. So that's what I'm doing over the weekend. That's what we're going to be doing next week. I hope, the customs didn't open it. They X-rayed it and they said, okay, that's what's there's only like one item on the invoice and there's like 14 things in this box. So they're sending it back. It's a pain in the ass. It'll get sorted out eventually. It'll get sorted out. We'll work on it. We'll keep you posted, but one's coming on Monday, whatever that is. I can't remember where it's from. But yeah, we'll do that. I don't really have anything else to talk about. That's it. I'm going to go to sleep so I can wake up nice and early and head off to Seoul and enjoy stuff. Yeah. So there we are. Let's head our poll, our like and subscribe poll ended up with 70% of you saying she should be held criminally responsible and 30% saying no. Thank you for that. All right, let's go over to good logic and say hi. Let him know that Legal Vices sent you. He has got that Legal Vices raid. Y'all take care, and we'll see you on Monday. Until then, whoever you are and whatever you're doing, whoever you do it with, just make sure you enjoy those legal vices. It's me, Lorax, saying have a great weekend. Bye, everybody.